Are we online now? Okay, so I can start. Welcome to our joint event organized by Young İstak and Altınbaş University. Our topic is very hot today, especially after the pandemic. Online hearings are very popular and very also debatable. But before going to our topic, I would like to give the floor to the opening speakers. First, Professor Ziya Akıncı, who is the president of İstak, and then secondly, Professor Leyla Ateş, Dean of Faculty of Law, Altınbaş University.
Thank you, Selda. Thank you very much. I guess the language of this conference is in English, but please allow me just to say hello to the Turkish speakers. Güzel bir konferans dileğiyle hepinize selam, sevgilerimi sunuyorum. Konferans dili İngilizce olduğu için açılış konuşmasını da İngilizce yapmam istendi. O sebeple hoşgörünüze sığınarak bundan sonra İngilizce devam edeceğim. Well, I'm very pleased and honored to participate in another Young İstak organization together with Altınbaş University. You may know that for İstak, Young İstak is one of the most enjoyable project for us because the young fellows are very important and we are very happy to see that the young generation of Turkey is coming, and this is very pleasant for us, and therefore this kind of activities are very precious for İstak. And we are very grateful, and thanks to Selda and her team, we are having another good organization through İstak and Altınbaş University. I also would like to thank to Altınbaş University for co-hosting or hosting this organization. Altınbaş University is an important university in Turkey and in Istanbul, and we have lots of friends and distinguished colleagues in this university, in law faculty, of course, for us. So therefore, it is a particular pleasure for us to continue cooperating with Altınbaş University. Today's subject is virtual hearing. It became a part of our arbitration practice. As arbitrator, we conduct hearings through virtual hearing, or as counsel, we cross-examine, we plead remotely. So it is a new experience. Like the film says, there are different aspects of this new concept, good, bad, maybe ugly. And you are going to talk about the virtual hearings in details. I don't want to take too much of your time, but thinking a lot, and also thanking to the distinguished speakers, especially some of them are participating from abroad. Hopefully we can host them in Turkey again. It is a great pleasure. And also, of course, Turkish speakers, thank you for making this day. And I wish you a successful and enjoyable conference. Thank you. Goodbye and stay safe.
Thank you, Professor Akıncı. Dear colleagues, panelists, ladies and gentlemen, good afternoon from Istanbul. It is my pleasure to welcome all the participants today for the virtual arbitration hearings in light of the due process concern panel as the Dean of Altınbaş University's Faculty of Law. We all experience an unprecedented situation with the global COVID-19 pandemic. It forced us to introduce and adapt to virtual classrooms, conferences, and meetings. Today, in our panel, we will discuss the possibility and implementation of virtual hearings. On behalf of Altınbaş University, I would like to thank all the eminent panelists that have come here to share their knowledge and experience with us. We organized this event in collaboration with Young İstak. I would also like to thank their organizing committee, especially John, Selda, and Esra for their support, and our research assistant, Esen. Now, I would like to let our moderator, Olivier Massiman, start the event. I hope that you have a fruitful time and enjoy the panel. Thank you.
Thank you very much.
going to Oliver, I would like to briefly introduce Oliver. And today our moderator is Oliver, and he's working as both counsel and arbitrator in international arbitration proceedings, and he's very experienced in arbitration-related court proceedings. He is a partner at Keller Harker and co-chair of the arbitration practice group, and he was also the co-chair of ASA Below 40, and we had very, very successful events in Istanbul and Geneva together. So we are very happy to have him today with us. So I wish you enjoy the event, and thank you for today being with us. Thank you, Oliver.
Thank you very much. Thank you for having me. I second the invitation, which I very much appreciate. I think it's great that, as Professor Akinci already mentioned, that ISTAC has the young practitioners involved via Young ISTAC, and also grateful for Altınbaş University to host this event. And indeed, I would like to come back to Istanbul. As some of you may know, we had an event in Istanbul prior to travel restrictions and everything. That has now unfortunately come up. There was, at that time, I was involved via ASA Below 40, the Swiss Below 40 organization, and together with Young ISTAC, we organized this event in Istanbul. I also would like to be there another event in Switzerland, of course. So for all the Turkish colleagues who would like to travel to Switzerland, or who are maybe based even in or around Switzerland, to be able to participate as well. I'm no longer co-chair, so I can no longer organize that, but I will make sure that this will happen as soon as possible as well. So without further ado, I would like to start with the panel on virtual arbitration hearings in light of due process concerns, and briefly introduce the three panelists, the three speakers who are contributing today. I'll introduce them in the sequence in which they will be speaking. And first there will be Luca Grosselj. He's a Swiss qualified lawyer, and he is an associate at Schellenberg Wittmer's Zurich office, but previously was based in their Geneva office, is already very experienced as counsel in international arbitration disputes, and also more generally in cross-border disputes. He also has a sports law angle to his practice, which makes it very interesting, something I do as well. So I'm very glad we have him. He's also part of the committee of the Asia Pacific Forum for International Arbitration. He's their European representative, and he's the Switzerland Regional Ambassador for HK45. So that's the Hong Kong Below 45 group. So they allow you to stay longer, which is very nice, different to the Swiss organization where you need to leave after you're 40, the young organization. But he's also an avid sports person and cook, and understand he likes in particular Gözleme, Pide, and Borek, so something all of you can relate to, hopefully. Then second, there will be Dilber Devitre. She's an associate at Homburger in Zurich. She practices international, both commercial and investment arbitration, and she acts as both counsel and secretary in these disputes. She has degrees, bachelor and master's degrees from Paris 1 Panthéon-Sorbonne from France. She's also admitted to practice to the bar in France, but she's also a member of several below 40 arbitration associations and groups, and including she's a member of the steering committee of the Young MCIA. She's fluent in English, French, and Hindi, and maybe on a personal note, she's an avid gardener, baker, and foodie. So maybe I think she and Luca can relate very well there. And finally, last but not least, we have Serhat Eski Yoruk. He's a lecturer and academic at Adana BTU Faculty of Social Sciences. He's also a research fellow at the Ministry of Energy Legal Department. He acts as both arbitrator and counsel, and in addition, also legal expert in international arbitrations. He is the founding president of TBB, the Union of Turkish Bars Arbitration Center, and he also quite a list of additional positions and membership functions. I cannot all list them today, but he is certainly highly active in the field of international arbitration. He is on the list of arbitrators of several international organizations, and he holds a PhD of the University of London. Very pleased to have all three of you, and I'm very much looking forward to our discussion. And I think without further ado, I would now give the floor to Luca to start his presentation. Just maybe as a preliminary note, there will be 3 short interventions by all each of the panelists, but each time there will be an opportunity to discuss with all 3 members of the panel. And to all of you who are now streaming this live, you can forward your questions, and we will try to have them answered by our panelists. Thank you very much. Luca.
Good afternoon, good morning, good evening, everybody, wherever in the world you may be. Thank you very much, first of all, to Zelda and Esra of Youngestack for their very kind invitation to speak at this webinar. I also wish to thank the Altınbaş University for the flawless organization of this event. And it is indeed a very topical issue that we're discussing together today. Olivier, can we share the first slide, please? Next slide. Thank you. So let me start by trying to define what virtual hearings are. Virtual hearings are a typology of hearings that are conducted using communication technology to simultaneously connect participants from more than one location. This can be done through telephone or video conference. But why is this topic relevant? And what is the arbitration user's stance towards virtual hearings? The topic is relevant because our line of business was really introduced to virtual hearings through the COVID-19 pandemic. Today, nobody really knows if and when things will get back to normal and what that normal will be. As regards arbitration users, a recent study conducted by the Queen Mary University in London in partnership with White & Case found that if a hearing could no longer be held in person, 79% of the respondents would choose to proceed at the scheduled time as a virtual hearing. Only 16% of the respondents have said that they would postpone the hearing until it could be held in person. This same survey reports that only 8% of the participants cited due process concerns as the main disadvantage to virtual hearings. So this survey, in my view, goes to show, first of all, that virtual hearings have become acceptable and users have become used to them. And second, that although due process does not seem to represent the user's main concern, it can still taint the arbitration process. Next slide, please. In this part of my talk, I will briefly deal with the question to what extent virtual hearings are permissible. National laws, that is the lex arbitrii, generally do not contain any express provision recognizing a right to a physical hearing. However, it is said that this right might be inferred by way of interpretation under few national laws, such as in Venezuela or Ecuador. Conversely, a limited number of laws and arbitration rules contain express provisions dealing with virtual hearings, and generally they allow them. So for example, the Dutch Civil Procedure Code allows virtual hearings expressly. And in terms of arbitration rules, you have Article 27.2 of the new Swiss Rules of International Arbitration, which will enter into effect tomorrow, that also expressly allow virtual hearings. Some commentators argue that the absence of any clear provisions in national law must be understood so as to prohibit virtual hearings. The majority, however, consider that the ultimate decision to hold virtual hearings in a case of a clear legal provision to this effect falls within the arbitral tribunal's powers concerning procedural matters. And this is the case in Switzerland, pursuant to Article 182, subparagraph 2 of the Private International Act. The most delicate situation in practice to be addressed is therefore when one party requests a virtual hearing while another opposes it and insists on a hearing in person. To solve such an issue, tribunals tend to apply an overall balancing exercise. Concretely, this means that tribunals need to compare the potential benefits resulting from virtual hearings with potential prejudice to any party resulting therefrom. As far as I know, but I may be wrong, so don't hesitate to comment in the comment box on YouTube, there are to date two main decisions relating to the permissibility of virtual hearings against the consent of one of the parties. Next slide, please. The first such decision is a global landmark decision by the Austrian Supreme Court that confirmed that an arbitral tribunal's power to hold virtual hearings over a party's objection and rejected due process concerns. The second decision is a Swiss Supreme Court decision of last year in the context of Swiss domestic procedure. There was no sufficient legal basis, according to the Swiss Supreme Court, to order a virtual hearing without the consent of all participating parties. But as I said, this was rendered in the context of Swiss civil procedure, so it's highly irrelevant in arbitration, at least from a Swiss law perspective. We can move to the next slide. So in this part of my presentation, I would like to briefly touch upon the main due process concerns that arise or may arise during a virtual hearing. To that end, I'm going to address some important examples. Of course, this list is not exhaustive, and you may feel free to complete it. The first example I have is that there is no certainty that network connections, equipment glitches, or other technical problems will not arise during a remote hearing. In lengthy and complex hearings, these small hitches can be disproportionately disruptive to a party to present its case. One can think of a situation in which a witness that does not feel comfortable during cross-examination hides behind bad connectivity or unintentionally switches off his camera. If the tribunal nevertheless proceeds and refuses to repeat that part of the hearing, a party's right to be heard might be infringed. Second, there is legitimate concern that a witness or an expert can be coached or in any other way unduly influenced during his examination. A witness, where it turns out that he has been helped by a party, so-called witness coaching, would be distorted, and therefore the party would suffer and would be in a disadvantage against the other. The third example I have is the one relating to situation where one of the parties can prepare the hearing by in-person meetings with its clients, co-counsel, witnesses, whilst the other party cannot do that due to travel restrictions. That party then can argue that in such a case, its right to equal treatment is not fully respected. Fourthly, if a party is examining a witness who can only speak languages that are not used in the arbitration, the need for consecutive interpretation would cut the available time for the examining party in half and could lead to an unequal treatment if no additional time is allocated to it. The fifth example I have is where at least one of the parties is based in a different time zone from that of the tribunal or the counterparty, and the tribunal fails to accommodate for shortened sitting days within usual business hours. One party may be at a disadvantage against the other. For instance, if a hearing between a Turkish party and an American party takes place between business hours in Turkey only, the inequality towards the American party may appear obvious. And finally, as a final example, conducting hybrid hearings may possibly curtail the right to equal treatment of a party. As you are certainly aware, a hybrid hearing is a hearing where one party or a number of witnesses are in the same physical room, while other participants connect remotely from elsewhere. The potential detriment to the equal treatment of the parties appear obvious if only one party or its witnesses are in the same hearing room as the tribunal, but not the other. With this, I'm done. I finished my short presentation, and I thank you very much for the kind attention. Back to you, Olivier.
Thank you very much, Luca. I think this is already, you have provided a nice introduction and overview, and a little bit you've highlighted a few of the issues that could arise here. And maybe with that, we can start with a few questions already before we move over to the next presentation. And I think it all boils down to one key question. And I think you've already said it, but maybe let's follow up on that and also hear the view of the other panelists there. I mean, is there a right to a physical hearing? And I understood, Luca, your answer would be generally it's rather no, but maybe you can expand on that.
Yes, sure. You know, ICA has just published a series of country-related reports, and the conclusion of that research is that there is no right to a physical hearing in the lex arbitri of any country. There are only two countries which stand out. These are Ecuador and Venezuela, where it can be inferred by way of interpretation of the local civil procedural laws that there might be a right to a physical hearing.
And maybe Serhat, do you have anything to add now from a Turkish perspective as well? So would you agree there's generally no right to a in-person physical hearing in international arbitration in Turkey?
Thank you very much, Oliver. I agree to Luca, but it's very important that the judges get familiar with this process, so then they can also put a way forward for this kind of interpretation. And that's also very important if a country is going to be referred as an arbitral country, that it is the lawmakers should be quick to adopt these changes. And as we see in many countries, including Turkey, also changes their laws that I will make short presentations afterwards. So it's very important. And I also, to conclude, agree that it is not a right, but it is very important that to interpret it in this way. And that's why the rules and the state laws are very important to take steps. And so I consider is not a unfair process to have a virtual hearing. Thank you.
Thank you. Maybe Dilba, do you have anything to add at this stage?
Just a quick observation. I agree that in abstracto, there is no right to a physical hearing, but I think the tribunal and the parties, you have to consider every situation specifically. There may be situations where a virtual hearing may not be apt at all for whatever reasons. Luca mentioned some, and I will also be discussing some coming up in my presentation. So in concreto, if you insist on a virtual hearing, then you could somewhere down the line adversely affect the party's due process rights. And if that is definitely going to happen, then it may make sense for the tribunal to go back to a physical hearing instead of a virtual hearing. So while I agree that in abstracto, none of the laws give you a right, an absolute right to a physical hearing, each situation has to be considered individually to see what is the best solution for that case and that situation specifically.
And indeed, we will get into that a little bit more further down the line. And before we get there, Luca, what is actually the rationale, or what is the purpose of even maybe potentially having an in-person hearing? And I mean, I just personally, and as you are as well, I'm trained on the Swiss law, and you also are trained on the Swiss civil procedure law, which is of course a bit different from international arbitration law. But why do we even have in-person hearings? And do you really believe this is something, this purpose is something that still applies in international arbitration? You are on mute, Luca, sorry.
Thank you. No, the underlying reason that is often evoked is that there is a fundamental right to a hearing in international arbitration. And this would give the opportunity to the parties to present their case and more generally their right to be heard in adversarial proceedings. And as you said, in Switzerland, I think there is not even a right to a hearing at all in arbitration. And in addition to that, there is no right to cross-examine the other side's witnesses in Switzerland.
Do the other panelists have also a view on that question? Serhat?
Maybe I can add. I'm not a Swiss law expert, but I just know that in July 2020, the Supreme Court, Federal Supreme Court, interpreted the word appear as a physical presence. So it's very important that about the rules, applicable rules, and maybe is also influence the judge to interpret it this way. So that's also important, even in Switzerland, is to have that we know that it's a very liberal country, but it can have such kind of interpretation. So it's very important that we step, or the tribunal makes as a like a IBR rules guidance, make reference that it is a right of the tribunal to have a remote hearing, even it's on its own. So it's very important to have to present in its rules. Thank you.
Well, thank you. I think it's interesting when when you're speaking about international arbitration, we always talk about whether there should be or needs to be an in-person hearing, and what we think about is really cross-examination of witnesses and things like that come into play. But when you, and that's maybe a little bit the background of my question, when you come from a civil procedure law background more, and specifically now from a Swiss background, very originally, the purpose of a main hearing in a litigation, not in international arbitration, was really to have the public at the hearing. So there's a control, there's checks and balances on how the court works. And it's interesting, no, an arbitration hearing is not public. It's by default, it's typically private. It's just between the parties and the tribunal. So it's interesting that we're discussing about something else. It's really about evidence, and it's about equal treatment of the parties at that hearing. And this brings me a little bit to another question. Do you think it makes a difference whether it's a full virtual hearing or whether it's a hybrid hearing? So meaning that whether everybody can participate or just part of the parties can participate. With these considerations in mind, does it change? Or Luca, have you come across a case that deals with a hybrid hearing?
Just before answering the question on hybrid hearings, there is maybe one exception where arbitration hearings might be public, and that's in the specific, probably specific context of courts of arbitration for sports hearings, where one athlete can request to have a public hearing. So that's the only exception that I know. And then in terms of virtual hearings, I've come across proposals for virtual hearings whereby some of the parties or some of the witnesses would be in the same room as the arbitrators. But for example, our clients could not attend that hearing and be in the same room. So we opposed to the hybrid hearing for reasons of equality of treatment, arguing that basically if you can be in front of the arbitrators and we cannot, we are at a disadvantage. So this is something that I came across in my practice. So I would say that the short answer is either you have fully virtual hearings and everybody goes virtual, or you have full physical hearings. For me, virtual hearings, it's not something that works.
Do the others agree, or do you have a different view?
Maybe just to play the devil's advocate, although
yeah.
I quite agree with Luca, I would also prefer either full virtual or a full physical instead of a hybrid. But even before all this pandemic hit, and before virtual hearings became so popular or so necessary, I have seen some form of hybrid hearings. For example, an expert couldn't fly in, or it was too short for him, or the time zone didn't work. And we have had physical hearings where we just had one expert broadcast on a screen and giving evidence virtually. And it does work. So there could be a situation like that where the parties are okay with one expert being examined virtually, where everybody else is in the physical hearing room. So again, I think it's very situational, the answer, although I do agree with Luca, and I would also prefer for equal treatment and due process that either we have a full virtual hearing or a full physical hearing.
Maybe one final question. I think then in the interest of time, we will need, sadly, to move forward, but also luckily we will have Dilber up next. Do you think it's advisable for the parties to include anything with regard to hearings in general, and more specifically in-person or virtual hearings or even hybrid hearings in their arbitration clauses, or is it something that they better should leave like it is with the default arbitration clause?
I don't want to spoil Dilber's presentation, but no, what I would like to say is the sooner you put something in either the arbitration clause or in the procedural rules, the better, for clarity reasons. I think this would be my short answer, but I don't want to say more if Dilber wanted to present anything on that.
No, absolutely. I mean, this is the start to my presentation. So Olivier, it's a very good question to get into my presentation. But yes, absolutely. I don't think it's advisable. I think it's far more than advisable. It should be done. It should be done if you're drafting an arbitration agreement now for the future, or if you're starting an arbitration, then in the first procedural order, or if you're already, well into an arbitration, then, as I was going to say in my presentation, have a specific procedural order for the virtual hearing or the hearing that the parties decide to have. But documented, I think the best possible way to avoid problems down the line is having something documented as far as possible ahead.
So maybe that's the perfect fade over to your presentation then. So why don't you just start with it, and I'll try to just pull up the slides so everybody can see them. Just 1 second. I need to share again my screen and need to go to the right presentation. Sorry, I'm almost there. Okay, please.
Super. Thank you so much. I hope everyone can see the screen. So yeah, we'll just I'll just dive straight into some practical tips on virtual hearings. So we heard Luca spoke about the legal aspects behind it, and whether we should have a virtual hearing or not, and what are the due process concerns that arise in virtual hearings. And what we also want to talk about is how do you avoid these due process concerns? Is there anything that you can do when you're planning a hearing or even before that to make sure or limit as far as possible the due process concerns that could arise during a virtual hearing? So I've just divided up the presentation very quickly into sort of three aspects, three accesses that we would look into: logistical, technical, and then a bit also on behavioral considerations during a virtual hearing. So let's dive straight into the first point, which is the logistical considerations. Olivia, if you could just go to the next slide. Super, thank you. This is exactly what we were saying right now when we were discussing whether or not it should be documented in the arbitration agreement. My point of view is it's best to have everything written down as much as possible. And, like we had procedural order number 1, which would cover the entire proceedings of the arbitration. Now, more and more I see, and I think it's an excellent practice to have a virtual hearing procedural order, a virtual hearing protocol, which would note down or would have in a written form for the parties and the arbitral tribunal all the decisions that have been made concerning the virtual hearing. So all the modalities of the virtual hearing, how it will be held. For example, who will participate in the virtual hearing? Very important question. Who is the host of the virtual hearing? Which platform are you using for the virtual hearing? What rights does the host have during the virtual hearing? are your cameras meant to be on or off during the virtual hearing if you're not speaking? I mean, these are details, but the more, my opinion, the more detailed the procedural order is, the less problems you have down the line, and more difficult it is for a party to then complain if it has already agreed to something with the tribunal or has not objected when the tribunal issued such a virtual procedural order on how the virtual hearing would be conducted. So these are very important issues that should come out and that should be noted down. And I've already seen now arbitrators starting to have a prototype of a virtual hearing procedure and sharing that, and then you adapt it sort of from one virtual hearing to the other. So this is something we learn with experience, and every hearing you attend, you add something to your virtual hearing protocol on something you had learned or experienced during a virtual hearing. So I think that's the most important piece of advice what I have seen in virtual hearing so far. Then obviously, what platform are you using for your virtual hearing? It has to be both appropriate and of course accessible. So when you say appropriate, I mean, think in advance of what you need from the platform. I mean, it could be a very complicated hearing spread out over a week with multiple witnesses and experts, and you may need a lot of functions. It could be a very simple hearing where just all you need is for the two counsel to speak, make opening statements, closing statements, discuss something, and that's it. So depending on the complexity, depending on the functions that you need, choose your platform accordingly. Choose a platform that gives you host facilities, obviously video facilities, that goes without saying. Do you need to share documents? Do you need to share your screen during the hearing? Think about that. Think about the security functions of the hearing, of the platform that you will be using. And we'll be speaking about this in more detail later, because security is a huge concern in virtual hearings now. Will the hearing be recorded? Who has the power to record? Only the tribunal, an independent third party? You don't want, anybody or everybody recording the hearing. So what security features does your platform offer you? This is something to be kept in mind. Does the platform offer you breakout room facilities? Because very often, like we had in physical hearings, but we also need virtual breakout rooms where only counsel and teams want to discuss their strategy and issues. So does the platform offer you that possibility? Does it have instant messaging possibilities? So if you want to write off an instant message to your lead counsel during a cross-examination without obviously the other party seeing what you're trying to tell him, can you do that through your platform? Or do you have to use, Messenger or some other form of communication with your team during the virtual hearing? That's also a consideration that you have to take into account during the hearing. Do you have separate audio channels for interpreters? Because sometimes we need interpretation also during the virtual hearing. So how do interpreters connect? How do they speak? What is the setup for interpretation during the hearing? Interface, does it have an easy interface? Does it allow you to see everybody on the screen at the same time? Can you choose, or you only want to see one person on the screen? How does it allow you to set up your screen? I think these are all issues that you need to consider when you're choosing your platform. I think nowadays a lot of virtual hearings are on Zoom, but I've also done one on WebEx, which wasn't so bad. Although I think personally I would prefer Zoom, but that's a personal choice. There are other platforms. There's Teams. So consider the technical capabilities of each platform and choose accordingly what you like. And obviously, of course, the platform has to be accessible to all the parties involved, because this would be a huge due process concern if for some reason a platform wasn't accessible to one of the parties. Then another tip that I found very, very useful during the virtual hearings that I have attended is to have a virtual hearing manager who's sort of the supervisor of the entire hearing. It's not someone who's involved in the case. So he's not someone who's at all concerned with the legal aspects of the case or the arguments or anything. His job is just to ensure that the virtual hearing runs smoothly, that if there are any glitches, any problems, he comes on. And this could be an independent person. I think that's the best if you could get an independent person to do this, or it could also be someone from the IT team of one of the parties or the tribunal, or the secretary to the tribunal who, if she's or he is familiar enough with the way the virtual hearing is to be held, can play this role. But it's really, really helpful to have someone there that is in charge of the entire hearing and the setup. And then I say have back office support staff. This is for each team. So the hearing manager would be in charge of the entire hearing, but have somebody from your team, again, who is not counsel, who is not involved in cross-examination, not involved in the legal aspects of the case, whose only job could be maybe to present slides or to make sure that that the documents are ready and ready to go out in the order that they have to, or that everyone's on screen, or that also someone who's in charge of the instant messaging, if you want to keep someone in your team who just plays that role. Have back office stuff, because when you're doing a hearing, you have it in a physical hearing, you will need it also in a virtual hearing. So have those possibilities on hand and provided for. Then we come to some quick technical considerations, which are of course very, very, very important in a virtual hearing. I mean, needless to say, make sure that everybody has the appropriate equipment, because without your equipment, you can't participate in the hearing. And this may sound obvious, but trust me, to all of us sitting here in Switzerland and Turkey, it may be, yeah, I mean, no biggie. We all have the necessary equipment, but we had a hearing where we had someone testifying from rural Romania. And, you know, sometimes internet connection can be a problem. If you don't have a very quick or a very, very strong internet connection that doesn't support video and audio, you have sometimes 20 participants on a call. You need a bandwidth that can really deal with that. Again, no problem for you and me, but make sure that all your participants have that possibility as well, and that there's not going to be someone's screen doesn't freeze in the middle, or the connection breaks off. That might happen, but just make sure that you have the equipment you need. Everyone in your team has the equipment they need to run the hearing smoothly. Obviously, your internet connection has to be secure. This goes without saying. Don't log into a virtual hearing from a Starbucks cafe. It's not a secure connection. It could really compromise the hearing. Know your platform. So once you've chosen it, it really, really makes sense, I think, for counsel or everybody to spend, I don't know, half an hour just going over the platform again, knowing the functions and the tools that this platform offers for yourself. So if something happens during the hearing, you can also, you know how to intervene yourself. So for example, if suddenly you get a cat filter on your face during the hearing, you know how to turn it off. As simple as that. Just know your platform before you get into the hearing, because if something goes wrong during the hearing, you're likely to be very flustered and, oh, how do I do this? Or what do? I don't know what to do when you're on camera and everybody's watching you. So take time beforehand. That's something that helped me. And obviously with every hearing, you will get more familiar with the platforms and better adapted to using them. But if it's your first hearing or something, it's always worth to take a minute of time and know your platform well. Test, and test. I can't say how important this is. Just before this call, I tested my webcam and my camera this morning, and everything was working fine. Just when we were doing a group test for this call, my webcam didn't work and my speakers didn't work. So, you know, it was, okay, what happened suddenly? So I can't tell you how important this is to test in advance, and test using the exact same system and setup that you will use for your virtual hearing. Because it has also happened, for example, that people have tested from their home desktops and everything works fine. But then you get into your company's virtual desktop or something like that, and there's a glitch and you need a plugin that you don't have and it doesn't work. So test as if you are in the hearing. Have a dry run with your team, for sure, everybody on your team. Also, if possible, if the case is big enough, the resources permit it, have a dry run with the entire, all the participants of the hearing, including the tribunal, the counterparty. It can be like 15 minutes just to make sure that everyone can log in, sign up, and everything's working for everybody. And of course, if you notice issues during this dry run, then you would adapt your virtual hearing protocol accordingly. So you would change, maybe you think it's better that people have their cameras off when they're not speaking rather than on. So you could make adaptations to the virtual hearing protocol that is obviously a work in progress as well. Like I said, security and confidentiality issues. This is a huge concern in virtual hearings. It was, and I think we learn with time, we learn on the job as well. Every hearing, you know how to make it a bit more secure. So in the initial months of this whole thing, we heard about Zoom bombing and, you know, people coming in to meetings or hearings uninvited. There are lots of ways to get around this. One way is to ensure that the host has to allow everybody or permit anyone to enter the hearing. Without permission, they cannot get in. You could have a security code or a password that only participants have. Again, you know, the usual limitations of passwords apply there as well. But you can lock the hearing room so that nobody can access it. No unauthorized person can access it. So these are some considerations that you should keep in mind when you're setting up a virtual hearing. You have to consider how you secure that virtual hearing to unwanted participants who could infiltrate it. Very simple. Another thing you have to also ensure is, for example, that every participant is alone in a room or has the necessary confidentiality measures surrounding them. Again, you know, you don't want to do a hearing in a crowded room where people who have nothing to do with the hearing can hear you. That could be a huge confidentiality breach of the arbitration. So make sure that every person as well has a secluded location from where they can access the hearing. Preferably use headsets so that you're not on loudspeaker. So everybody around you, if it's not possible to seclude yourself, which ideally it should be, but if not, then at least other people don't hear everything that's going on in the hearing. These are some security concerns that come up and that must be addressed. Luca mentioned also witnesses and undue influencing witnesses during virtual hearings, which is again a huge concern and can happen, and unfortunately does happen. How would you address this? One of the ways is possibly to make sure that you see the entire witness on camera. So you make them sit at a certain distance from the camera, so you don't only see their hands or their upper body, but the chair and everything. Or you get now 360 degrees cameras that allow you to view the entire surroundings around the witness. You could ask the witness to put his phone in a position that you see he's not getting any messages from counsel during his testimony, or ensure that he has his hands in a place where they can be seen. These are small things. Unfortunately, they have to be done. They may seem extreme, but in virtual hearings, the temptation and the possibilities of interfering with witnesses and experts is so much higher than in a normal hearing that unfortunately these are mechanisms that have to be used during virtual hearings. Recording, like I said, ensure that nobody else is recording the hearing except the official person who is entitled to, if that has been agreed to by the parties. If not agreed to, then nobody should record the hearing, except, you know, maybe you have the live transcript going on through the hearing, but nothing else. So these are considerations that you should keep in mind. And finally, always have a contingency plan in place, because technical issues, even if you've tested everything, you're sure it all works, have a contingency plan in place in case something goes wrong, because you never know when something can go wrong. So have a list with all the participants' telephone numbers, official telephone numbers, in case you have to turn the video or the hearing off and get everybody onto a dial-in call immediately, just to decide what to do next in case there's a problem. And like, let's say a very important witness suddenly can't connect. What do we do? How do we discuss? Let's get onto a call and discuss. Or somebody drops off, or an entire team, one party's legal team has technical issues and can't get onto the platform. So always have a contingency plan in place, and keep buffer time for unforeseeable situations as well. Sometimes it takes longer for someone to connect. Sometimes someone's camera doesn't work while they've connected. So keep a little buffer time, a little bit more, to ensure that you can deal with all these contingencies that could arise during the hearing. A few words very quickly on behavioral considerations. This is not really due process, but these are things I've observed during hearings, and it's maybe worth mentioning quickly in this conference. Dress professionally, it sounds so obvious, but as time goes by, you see more and more people forgetting sometimes that these are actual hearings. These are not, this is not a basketball meetup where you can come with a head cap and jumper, or it makes a difference, I feel, to the quality of your presentation and the impression you make before your tribunal. If you don't want to wear pants or don't want to get dressed down, that's entirely up to you, fine, but just keep a huge post-it on your computer screen saying, please do not stand up and do not forget that. So keep that in mind. It happens to, even the French president. So plan regular breaks. Zoom fatigue is a real thing. It is a real thing for anybody who's been in a virtual hearing. It tires you out. I feel looking into a screen tires you out a lot more than being in a physical hearing, which is by itself also very tiring. But plan regular breaks, plan buffers. I think that's also why virtual hearings sometimes tend to take longer than physical hearings would. But maybe that's the way it is. Be conscious of your body language when you're on the camera. It's not because you're not in person in front of the tribunal that they can't see what you're doing, or everybody is still watching your engagement. Everybody is still seeing how you behave on camera as well. Use exhibits efficiently. Again, this is very important during a virtual hearing, all the more so because you're not physically in front of the tribunal and you can't hand over that document that you wanted, the exhibit C105, to the tribunal, which is so crucial. You can do this through document sharing. You can share documents on the screen, but very often also I find what helps is pinpointing exactly where in the document you want to draw the tribunal's attention to. So highlighting things in the document when it's on the screen, zooming in, zooming out, maybe even cut and paste, like take a cutting of the part of the document that you want to highlight and have only that shown up on the screen. And now there are more and more professional parties that do this as well in online hearings, and it can make a big difference to the advocacy of for your case. It can be much more efficient. So if the value in dispute and if the resources permit it, then it's something really worth looking into. If you have a huge evidentiary hearing that's going to be virtual, it could really help your case. And I've seen it done. We had the first hearing I went in for, we had one of our interns that was doing the document sharing and trying to zoom in and zoom out. And when you see what professionals can do, there are even videos where you can look at it now on the internet. It makes such a huge difference to your case and to the advocacy. So these are things you can keep in mind. And here I've just listed some additional resources that have come out in the last years on planning virtual hearings, which are very useful. They also have additional details and issues that you should always keep in mind when planning a hearing. And I think Serhat is going to go more into in depth in these guidelines. and guidance notes. So this is just out there for people that are interested in knowing where you could find the resources for planning virtual hearings. So that's it from me, and I'd be happy to take any questions if you have.
Thank you, Dilber. And maybe let's just get back to the question I asked you right before your, to the panel right before your intervention. And there I asked the panel whether it's advisable to include anything concerning hearings, and in particular virtual hearings, into their arbitration agreements, or whether to leave it at a default arbitration clause. And now based from your presentation, I understand that you believe it's strongly advisable to have it's sort of a procedural order, so a virtual hearing protocol. But at that stage, you already know what the dispute is about, who the actual parties to the disputes are, and you have an actual knowledge of the case at hand. Do you think it makes a difference based on that, whether you include anything already at the stage when you agree on the arbitration agreement in the contract typically? What is your view on that?
I think you can agree to the basic principle of a virtual hearing, yes or no, in the agreement itself. But I wouldn't go down into the details of the modalities. Obviously, that's too much to put into the arbitration agreement. But once the principle of a virtual hearing has been agreed upon, then it's quite similar to, you know, the way it goes when you have a physical hearing. As the hearing approaches and you start preparing for it, you often have a procedural order also setting out the rules that would apply during the physical hearing. And the virtual hearing protocol is just sort of the counterpart for virtual hearing proceedings. But absolutely, I think this level of detail you would need to do later on down the line, once you're agreed on the principle of a virtual hearing, and you know you're really getting down to the nitty-gritty details that have to be sorted out. But my point remains that I think both agreeing to the principle of a virtual hearing or not, and the details should, as far as possible, be documented in some form of from a procedural order or an agreement between the parties.
And maybe if you have it in there in the arbitration clause, you have an agreement on the principle that there may be a virtual hearing. Are there any disadvantages to this, or to put it differently, may the tribunal disregard such an agreement?
You would need a very brave tribunal to do that. I'd like to see one come up to do it. As far as I know, I don't think a tribunal would outright disregard it, unless there are very, very strong reasons for it to do so. And this is another reason why I think having everything documented in writing really helps, because even if you choose to go over, I would suggest one party's objection to the virtual hearing, but if the tribunal chooses to go over even both parties' objections to the virtual hearing, which is a bit more serious, you can set out why very clearly in a procedural order with every reason, addressing possible due process concerns that the parties may have, and why the tribunal thinks those do not justify holding a physical hearing and still holding a virtual hearing. I think that would save a lot of issues or problems down the line if this is set out very, very clearly in a procedural order and documented.
Maybe the other co-panelists, do you have any additional points or maybe a differing view?
I mean, nothing else to add, but as Dilber said very rightly, you want to keep this flexibility to adapt to circumstances down the road. So the principles must be in the arbitration clause, I would say, but then all the details, the later the better, when you exactly know what the scope of the hearing is, what the circumstances are. Otherwise, you might be prevented from that flexibility.
Olivia, just one, Luca just mentioned flexibility. I think it's important to mention this is a learning curve, at least for me, and every hearing that I've been in. You learn from the past hearing, or sometimes even on the ground during a hearing, and you have to have this flexibility open. Even, like I said, during the hearing, you may have something in the protocol and then you realize it doesn't work for this hearing. We need to change this. As long as everyone's on board, everyone discusses it, you can change it. You have to be I think a lot more flexible during a virtual hearing. That's from my experience what I've seen.
And then the question really is then, do you want to keep all the flexibility? That was a bit maybe the background of my question. Do you want to keep all the flexibility and leave it to the tribunal, meaning there's nothing in the arbitration clause? Or do you think that goes then too far because, as you said, at least then you have some basis for the parties for a virtual hearing and you take away some of the uncertainty maybe? But the question is there that much uncertainty? We've just learned that there is no right to a physical hearing in at least most jurisdictions. So why would you take away that flexibility from the tribunal?
Just to avoid that a party could in bad faith, raise objections later on. You want to try to reduce that as much as possible. Tribunals have general powers to conduct the proceedings under most rules and most arbitration laws. And we know that if a party wants, it can still create issues.
And maybe let's just quickly go to speak a little bit about virtual hearings on the one side and hybrid hearings on the other side. And I understood that you are a little bit more hesitant when it comes to hybrid hearings. What are the main concerns, and maybe how can these concerns be addressed when it comes to hybrid hearings in particular?
Well, my main concern for the hybrid hearing would be, I still think having a person in front of the arbitral tribunal face-to-face, when you can speak directly, it makes a better impression. And if I were counsel, I would not want the counterparty to have that advantage. And because my witnesses can't appear, have a disadvantage of having to present witnesses for my client virtually. So, but it would also depend on the witness itself. Some witnesses also have an amazing aura or personality and can convey themselves just as well through a camera. So it would also depend on the personality of the witness or witnesses in question. If I'm sure I don't want someone on camera, I would not agree to a hybrid hearing if the other party is bringing their witnesses in person. But on the other hand, I may prefer to have someone on camera and not in person in front of the witness, in front of the tribunal, if I know that witness is really nervous or has a nervous personality. So I think it's a combination of these factors. It's a difficult decision, and like I said, it depends on your witness, on the tribunal as well, a little bit. I think some tribunals, if you know your tribunal is likely to engage more with the witness personally, to believe them more personally when they meet them personally rather than through a camera, this would be something that I would take into consideration. Maybe not officially, maybe it's not an official reason that you could mention to the tribunal directly, but it's definitely something as counsel you'd look into when you decide whether to agree on a hybrid hearing or not.
Thank you. And now we have discussed how we could maybe change our approach when it comes to drafting arbitration clauses, and also for the tribunal, how to come up with better maybe procedural orders. And let's now go to the next presentation, which is Serhat's presentation, and this will include some recent laws, rules, and protocols that address these. So all of these new issues. So maybe Serhat, the floor is yours, and looking forward to your presentation.
Thank you very much, Oliver. First of all, I'd like to thank you, Altınbaş University, our dean, Professor Leyla Ateş, Esen Hocam, and Young İstak organizing committee, Can Bey, Selda Hanım, Esra Hanım. Thank you very much for kind invitation. It's my pleasure and honor to be with you together in this webinar. Actually, my presentation, I will make my results with your question, actually, about the arbitration agreements. Now, I would like to actually show the national laws and institutional rules, the developments, and whether they have effect, and also whether it is important or not. And we have just discussed that for a fair hearing, arbitration agreement is critical. It's not very likely to have writing very in detail about the arbitration procedures in an arbitration clause, but we see how important the arbitration seat and arbitration institution. And it will also cause this, whether it might be a cause for a fair hearing issue or not. So let's look at the countries. I started with my country, Turkey. We see the Code of Civil Procedure and International Arbitration Act. We have two legislations. One of deals with the national arbitration, and the other letter is deals with international arbitration. We see that last year there's an amendment in Code of Civil Procedure. It's very critical amendment in Article 149. Now it's expressly allows the judge on its own initiative, if a request of a party, one of the parties and the others even objects, it can deal and make a hearing remotely in a video conference or audio conference. So it's very important. Why it's important? I mean, it's a way of interpretation. It's when there is a challenge, the judge will probably use as a reference this Code of Civil Procedure. Although this Code of Civil Procedure provision doesn't directly link to arbitration, but the judge will likely use it as a reference as a public policy issue, or whether it violates fundamental principles. So I take it very seriously, even in Turkey, and I will mention the other countries in a minute. So, an International Arbitration Act, but there was a case in 2018 and decided in 2019 as one of the fair proceeding issue, and the local court, Istanbul Commercial Court, decided that it is not an issue of fair hearing. The claimant should prove, other than just having a video conference, violates a fair hearing. The third issue I would like to, I mentioned the Code of Civil Procedure, national, which deals with the national arbitration law, and the second, the International Arbitration Act. I would also like to mention about our national judiciary IT system. We call it UYAP. Now it's electronic hearing portal we have. Now I just checked that there's 679 courts, including in 28 cities. Now there's e-hearings. So it's again very important that the judge are now get used to virtual hearings and how to interpret the fundamental principles and public policy objections. And in Turkey, I would like to also mention another developments about our institution, the İSTAK, Istanbul Arbitration Center. In early 2020, announced this online hearing rules and procedures. It is very pioneering actually approach. Just at the very early stages of this pandemic, İSTAK was very quick to respond. So it's the importance of the institutions, how they respond, how they adapt, how they quickly react these developments is very critical for this also, whether they have a real international arbitration institutions, whether they have, they will be also. So let's look at the other countries. Oliver, may I ask? Sorry. When we look at the other states, the Austria Supreme Court is one of the, I think it's the pioneer courts. The Supreme Court gave decisions that it is available to have a virtual hearing, or a video conference, even one of the parties objects to have that. So it's very important, and many countries take as a reference to their decision, this Austria Supreme Court decisions. And we see in other liberal countries like Australia, in a case, it is just having a video conference. It's not just about a real unfairness or real practical injustice. It's very important, this kind of references. So they quickly adapt the changes. Again, Canada, Ontario Superior Court said that we shouldn't go back. I mean, we should use, it is the efficient way, efficient, quick, and responsive. I mean, of course, as Dilber mentioned, it's a case by case. We should discuss whether there is unfairness issue the court should look at, but just the issue having a remote hearing is not an issue of a unfair jurisdiction hearing. Denmark again accepted a witness testimony as a remotely. Egypt Court of Cassation is said it's consistently with the Egyptian law. England and Wales English law says accepted a remote hearing, and also in a family court case in rare children, but still it says that it is not an indispensable element of a fair hearing. So in other countries, when we look at like Hong Kong, can we just Oliver continue, please? It's a court of appeal says it's a permissible and lawful. Germany, of course, they didn't really make a specific law, but it says it is not required to have a physical presence. France, it is active and it's regulate online arbitration. It's not directly related to remote, but it shows that the states are quick to respond. It's very important. That's why I would like to highlight that the importance of the seat at last, because the challenge of an arbitration award is going to take place in an arbitration seat. So that's why the choose of arbitration is very critical. India, Delhi, the High Court says physical is not compulsory. Singapore, again, it is not against. Civil law I mentioned, it's a different interpretation, but it's likely to also allow, but it says that it is not just a right. UAE, United Arab Emirates also allowed in their 2018 law, it allows this kind of interpretation. So when we look at the arbitration institutions, we see that the institutions, how quickly they respond is very critical, because at the end, they shouldn't risk the challenge of the arbitration award. It's their duty. So they have to quickly respond. ICC, we know that it's published a guidelines about the issue. So I mean, the arbitrators was flexible, and they know that it's their right, and the institutions presented a guidelines. But although for that, ICC just renewed its arbitration rules. Now there is a new article. It expresses states whether the tribunal has the authority in ex officio, whether to take the hearing in person or remotely. LCA again changed its rules. CIVIS, chambers, arbitration institutions, just I think tomorrow is going to get into force. It's a new article about that. AAA, American Arbitration Association, just last month, there's a new, again, for international dispute resolution, there's a new clause. The FCLCA in Dubai, as you know, Dubai International Financial Center, there's again new clause for that. Czech courts, also important amendments they follow. So it just shows that if you would like to lead, you have to adapt quickly. And these states I believe they proved their capabilities. And as we know that these are the most used, ICC, LCA, AAA are the most used arbitration institutions. And I think they didn't want to, they want to make an express reference to that. And in addition to your question and also Dilber's answer, I also would like to refer to IBA rules and on taking of evidence. Sometimes there's we can see on arbitration agreements, there can be reference. And in 2021 version makes expense reference again to remote hearings. So it's very important if there's a hesitation. And as we know, there's a protocols, guidelines, there's a CIF, Seoul, Hong Kong, Vienna, ICSID, they all make protocols that Dilber also mentions. Now I cannot take into details. If any question arise, I'm happy to answer. So at the end, I would like to raise that it's very important to have a very good arbitration rule, like institutional rule. As to remove any risk, it's very important as a protocol, or the arbitrator makes a terms of reference, or make reference to like an IBA 2021 guidelines. So it also impliedly allows remote hearing. And so it's because it's a soft law instrument, and also whether case by case it should be considered. And maybe in addition to that, I just like to think that if there is a difficulty, the tribunal should be also open to new solutions. For example, they can, if there's a cross-examination, we just discussed, if there's a hesitations, for example, maybe Dilber very good explained how the technical structure can made to make a cross-reference, like to 3060 cameras, etc. All very important technical issues should be considered. But also there can be also cooperation with local arbitration institutions, for example. And such kind of new approaches should be taken by the arbitral tribunals. So as a result, I agree the first question, it is not a right to have a physical, but it should be a fair hearing. The tribunal should be very careful. The parties should be very careful about the arbitration seat and institutions. And but as a overall, it is a new concept. We should be adapt and say it is not as we should all be very flexible, the tribunals and the councils, and available and adaptable to these new developments. Thank you very much.
Thank you very much. And maybe let's just follow up on your overall conclusion. And one thing you refer to is let's say the case by case assessment of whether a virtual hearing is appropriate. And we actually got a question on that from the audience. And the question is, do you think virtual hearings are more fit for some types of cases, such as expedited arbitration, minor claims, or less complex cases? So what do you think, are virtual hearings more fit for that?
It can be said in that approach, but what I normally think about is it is adaptable most of the cases. Maybe some in cross-examination issues, as I mentioned, there should be more careful approach should be taken, and the fair consideration, if it will cause any unfairness, should be taken very carefully by the tribunal. So as I mentioned, technical structure can be made for that purpose, very well prepared, or it can cooperate with other institutions, or another solution can be made. As an overall, I believe it's applicable for almost all cases, but in some, especially in cross-examination, it should be very well developed, the structure and also the technical issues. I just would like to add. Thank you.
And I believe
Maybe
Luca,
Dilber.
Yeah, sorry, Dilber, and then also I think Luca has a story to share, but whoever wants to go first.
Yeah, I can go first. So yeah, I think that virtual hearings or hybrid hearings could be really good when it comes to emergency proceedings. So I even had a story before the pandemic where we had to hear 6 or 7 witnesses within very short notice. And the emergency arbitrator, he invited the counsel to come to his law firm for the hearing, but all the witnesses were heard remotely. And this was not an issue at all. Probably the witnesses could not travel within such short notice. Plus it was the 23rd of December and all witnesses were in the US. So they would have missed probably Christmas if they were to come to Switzerland to attend the hearing. So I think for emergency proceedings, that's one, I would say, type of hearings that is really fit for virtual or hybrid hearings.
And Dilber?
Yeah, I agree that some hearings, some types of cases lend themselves better to virtual hearings than others. And just to give example from my own experience, I've had 3 virtual hearings over the last year. And one was a really easy sort of contractual interpretation case where there was nothing overly complex or you know, we didn't have a lot of exhibits. It wasn't very evidence-based, for example. And a virtual hearing in that case was perfect. Each party presented their point of view. The tribunals heard it. There were a few legal exhibits that we had to read out. That was perfectly fine. And another case was this huge, massive construction case where a lot depended on taking the tribunal through very detailed construction drawings and technical diagrams and things like that. And for this case, it had to be virtual because it was during the COVID times. But personally, I felt it would have been so much more effective if it had been in person. So I definitely think there are types of cases where you can say, yes, you're virtual, you know, we don't even need to, it would be a waste of time and money for counsel to fly all over the world and meet. But in others, it's definitely better to be able to meet in person.
Maybe to follow up on that, and there's also a question in this regard from the audience. I mean, I think when it comes to costs, you will probably agree that virtual hearings tend to decrease costs, especially in an international setting. But how about time? Does it also reduce the time that is required to go through the entire arbitral process? What is your experience there?
You go, Dilber.
No, go ahead. I just wanted to repeat something I said. I think virtual hearings could, for several reasons that I mentioned, Zoom fatigue, having to, you know, have a bit more buffer times for technical glitches and things like that. Also time zones, to take into account very different time zones that counsel often find themselves in. For all these reasons, virtual hearings could be spread out a bit more. It may not be reasonable or efficient to have the typical 9 to 6, you know, sitting of a hearing and finishing it off. You may decide to do it in a block one day and then morning in the morning, and then the next start again in the afternoon. And, you know, also take into consideration the time zone difficulties are maybe spread out more between all the parties. It may not be fair if one party has to connect every night at 2 or 3 o'clock their time in the night for a week. So virtual hearings could take longer for those reasons. They could be spread out a bit more. But at least in my perspective, I don't see that necessarily as a negative thing. I don't know if the other panelists have another opinion on that.
So I couldn't agree more with what you just said, Dilbert. But in my experience, the preparation of virtual hearings is super time consuming. So ideally, you would be able to have a paralegal or a team of paralegals that help you prepare and also communicate with the virtual hearing manager or the service provider that will gather the evidence that needs to be sent to the service provider of electronic presentation of evidence. So I would say, yeah, the preparation time is huge for virtual hearings, and that should not be underestimated.
May I just add, I agree with both with Dilbert and Luca, but I see is a must, especially if there's the tribunal has a choice between suspension of the proceedings or not. I mean, it may have some cost, but many now institutions have this capability and this structure. So I strongly suggest, for especially in this time of travel restriction, it's very critical to have the availability for this process. Thank you.
Can I just pick up on something that Sedat just mentioned? And it's an interesting point, actually. I think, we were discussing earlier also, should we have virtual hearings? Is there a right? Is there not a right, etc.? I think a lot of it also depends on the situation. For example, when you have border restrictions, when people cannot fly, there are no flights going, or, no visas being issued, that is a hard stop. You can't, there's no way, there's no going around that. You can't say, I still want to have a physical hearing, even though Switzerland is not issuing visas for anybody outside the EU right now. There's nothing you can do. But is it the same, or will it be the same in the future when we won't have these hard stops or these very strict health restrictions, like, no more than 5 people in the same room because of Corona? Hopefully this pandemic is going to go away someday, and things will sort of return to what it was earlier. And then the question comes in, are we still going to see virtual hearings being used as much? Our tribunals, because then it won't be a hard reason or a compulsory reason not to have a physical hearing. It will be more for convenience reasons. And it would be interesting to see what tribunals think or tribunals do in that situation, when it's just more convenient and not necessary to have a virtual hearing over a physical hearing.
Yeah, thank you for that outlook into the future, and it's the future after the pandemic and of what's going to come. It's also, unfortunately, now we've reached the end of this panel. I enjoyed all of your 3 presentations greatly, and thank you very much for your great presentations, your input, and all your answers to the questions, and the lively discussion. Thanks again to the organizers. It was great. I hope the audience enjoyed it as well, and you can still review or go through everything again via YouTube. Have a great day, and bye-bye. See you soon. Thank you.